So we were discussing the third part of the chapter first. Some definitions has been provided here that we have to discuss and understand. And I'm taking one by one. The first one is fact. You know, this fact word is very common. You have heard in many trials, many movies where the criminal trial or the civil proceeding is shown. There are two words, like one is fact, another is opinion. Fact and opinion are two different things. Okay. Now the question here is that on a particular, like suppose the height of this or the length of this pen. Okay. So the length of this pen suppose is 6 inch. So this is a fact that it is 6 inch. Or this is pen, it is also a fact. Okay. And the opinion may differ from the person to person, whether you like it or you do not like it, in which there may be the variation of the fact, there may be the variation in the opinion, but fact will remain same. If it is a pen, no one can say that it is not a pen. So that is the basic difference between fact and the opinion. So if there is a question of the fact, it will remain unchanged in that situation. Not absolutely. And the opinion may vary from person to person. Okay. A man has 50 kg weight. It is fact. And maybe from one person, he is fat. From another person, he is not fat person. He is perfectly perfect person. So that means the fact remain unchanged. It cannot have the two opinion, and the in the opinion they may that may be different from person to person. Now the question is, what is fact? Can any of you, in the general parlance, define that what you understand by the word fact? Okay, then I will take the meaning as defined under the Indian Evidence Act. Yes. Yes, guys, please, quick. Mahesh, Mr. Mahesh. Mahesh, are you listening me? Unmute yourself.
Yes, sir.
अगर आपसे कोई पूछे कि फैक्ट को आप डिफाइन करो, हाउ यू विल डिफाइन फैक्ट?
Sir, fact can be any that attribution of anything which cannot be changed, which remain as it is.
Good, good, good. Yes, I'm taking another person. Kritika Malik. Kritika Malik, are you listening me? Don't hesitate. Don't hesitate. Udichi?
So that person can perceive by sense.
Good. So when a person perceives something, it is fact. Yeah. So this is, we understand in the common parlance. Now I'm taking the legal meaning that has been assigned by the Indian Evidence Act. If you have the Evidence Act, you can also, read with me. Fact. This is the second para of the section 3 interpretation clause. Fact means and includes. Means and includes. Two words are used here. If you allow me, I want to explain you that the meaning of this or the significance of these two words. See, there can be two type of definition. Okay. One is the exclusive definition. Another is the inclusive definition. You can write it also because it will be helpful for throughout your LLB. The exclusive definition is that exclude, like IPR, intellectual property right, is exclusive right. When you get the patent, other are excluded. When you get the trademark, आपने अपना ट्रेडमार्क जैसे यही लिखना शुरू कर दिया, आपका नाम है उदीची, तो the other will not use that Udichi name for their project. So that means the excluding the other. So the exclusive definition means whatever has been defined by the legislature, the meaning or the, the area of that definition will be of that much, and it would not extend to that beyond that limit. So it exclude other thing falling outside the definition. And the you know uh, important, you can say, the word by which you can find out whether it is exclusive definition or inclusive definition, when the word means is used, that means it is exclusive definition, and outside that we cannot use anything. Inclusive definition means that it has possibility to include some other things also of the same nature. So you will find in the various statute that some definition are inclusive. They made, intensely inclusive, that this thing includes this. Hmm? Student, or you can say the teacher includes the teacher, lecturer, professor, etc. So any other, like the instructor also may be included in that. So that is inclusive. And to find out that whether a definition is inclusive or not, the word includes is the you can say the main factor to find out that. Here the word means and includes is written so that the intention of the legislature was to first to give the exhaustive meaning, and then to include some other thing, similar thing also, if that is possible here. Okay. So the fact means and includes anything, state of things, or relation of things capable of being perceived by the senses. Three things: anything, state of things, and relation of things perceived by the senses. Here, and the second is also any mental condition of which any person is conscious. So basically, this definition includes both physical fact as well as psychological fact. The first part, or clause 1, is the physical fact that can be perceived by our senses. Focus is on our senses. We have 5 senses. I think you all learned these things in the first or second class. The nose, by which we can smell; the tongue, by which we can taste; eyes, by which we can see; ear, by which we can hear; skin, by which we can feel cold and hot. Now, all these things, all these senses, if anything that is perceived by these senses, that is fact. So this first portion is basically denotes to the physical fact. Now come to the first part, that anything, state of thing, or third is the relation of thing. You hear something, it is a fact, because you perceived by your ears, yes, this sense. You saw something, it is a fact. You taste something, it is a fact. In a murder trial, suppose you are the servant of the particular person who was killed, and in the room when you entered, you saw that the room was so cold. This is also a fact for which you can give the evidence. You smell the pungent smell in the room, that is also a fact. You saw there is the blood pool, this is a fact. You heard something, it is a fact. And these things you will find in the illustration also. Like the first illustration, that there are certain, the second, B1, the man heard or saw something is a fact. So anything that you perceived by the senses is fact. Three things are used, 3 words, 3 phrases are used in the first clause. One is anything, state of thing, and relation of thing. Then the certain object that are arranged in a certain order. This is the state of thing. This is fact. When you entered in the room, there is half glass of water. This is also state of things. It may be fact. Illustration A, that there are certain objects arranged in a certain order in a certain place, is a fact. A man saw something. Suppose in a trial there is the question that when A stabbed B, A said to the B that B, you have killed my daughter, that's why I'm killing it. So this statement, but when he said, this is also a fact. So the relationship A is the, or any type of relation between the two objects that perceived by the senses, that is also fact. Now the second portion is about the psychological fact. What is the psychological fact? In an inquiry, or if you take for example in a murder inquiry, suppose there was a murder by shooting, A shoots B. This is one thing. A shoots B with intention to kill B. This is second thing. So whether this person has the intention, ill will, good faith, any type of the mental condition of which a person is conscious, when this particular mental condition is revealed, is also a fact. But this fact is not a physical fact, it is a psychological fact. That's why I said that the fact under the Indian Evidence Act includes physical fact as well as psychological fact. In the judicial inquiry, whether a person has breached the contract in good faith or not, whether accused A killed B on the grave and sudden provocation, this is also the psychological fact, a mental condition of which a person is conceived. Okay. So A shoots B, a shooting is a physical fact, but his intention of doing is psychological fact. And evidence can be given of the direct and circumstantial. For the physical fact also, the direct evidences can be given. A stabs B, A shoots B, or A had the sexual intercourse with B, or A hurts B. For that, the direct evidence may be given, the person who saw it. Okay. Circumstantial evidences, suppose the firearm was in the hand of A when the police recovered or police caught A. The forensic or this report, what you say, that ballistic report conclusively say that the fire was the bullet was fired from A's gun. The forensic report suggests that the bullet that is present in the body of B actually killed B. So these are the circumstantial evidences. So for the physical fact, direct evidence and circumstantial evidences are possible. For the psychological fact also, there can be direct evidence, there can be circumstantial evidence. Direct evidence, A with intention to kill B, killed B, or stab B, or shoots B. When A confesses by his word, by the statement, it is the direct evidence. When A confesses in the court that yes, I killed, this is the direct evidence of his intention. Circumstantial evidence, the conduct shows. The conduct, when A fire on B, it was through the point blank range, directly to the head. This suggests that A was intended to kill B. He cannot deny that my purpose was to just एक डर पैदा करना था बी में. नो, आप हाथ में गोली मारते, साथ बगल में गोली मारते, डायरेक्ट अपने सर में गोली मारते. Or it was through the mistake that by another conduct may be suggested. So through the conduct also the psychological facts can be suggested. Now there are two other terminologies also that is used, factum probandum and factum probandus. Yes. Udichi has typed a message, sir. In illustration, the reputation of person in the eyes of different person can be different, and you said a fact is something that remain unchanged, then how the reputation is one of the fact. See, this is something that opinion, the reputation is opinion, but see the second portion of the definition, that a mental condition of which a person is conscious. If you even read the definition of reputation, that reputation is as such in the strict sense it is opinion, okay, but it is a mental condition. You have the reputation in the eyes of you, a person has a good reputation or bad reputation is as much, the fact as the physical fact. It is psychological fact. Though if you strictly see, you are right, it is opinion. Strictly it is opinion of that person. But the definition that we had in this Indian Evidence Act is not that strict. It includes both things. That's why I'm repeatedly saying the psychological fact here means the opinion. The psychological fact, I think I have missed out. The psychological fact here means opinion. So here the fact and opinion both has. Okay. Udichi? Yes. So sir, sometime, yes, maybe. Or yes, it is true that the opinion is also. Opinion also. When any mental condition is conscious, but see the chronology of our discussion. First, as such, we discussed that what is fact, what is opinion, what is the common parlance meaning of the. Now I am taking the legal meaning, and here I clarified that here the fact include both physical fact or psychological fact. Psychological fact, even you can say the opinion-based fact or opinion. Okay, so here both things are included, and that is with the purpose so that to include, because the various substantive provisions you will see like related to defamation, etc. There the reputation or the mental condition is required, or the opinion is important, as you said. So that is okay. Factum probandum and factum probandus. Factum probandum means principal fact to be proved. Like in a trial of hurt, A causes injury to B. This is the principal fact. In factum probanda, evidentiary fact from which the former follows immediately or by the reference. So hey, A hits B. This is factum probanda because it is evidentiary fact. If a witness give the oral testimony that he saw that A was, giving that injury, so that caused the hurt. So this factum probanda is basically the principal fact that has to be proved, and factum probanda is evidentiary fact from which the former follow immediately. These terminology you will find somewhere because both are related to the fact. So I just explained it. Now come to the second definition, that is relevant. But before that, you can ask anything that you have in your mind with respect to this definition, fact. Okay. आप सोचिए, तब तक मैं दो illustration भी पढ़ देता हूँ. That a man hold a certain opinion, has a certain intention, act in good faith or fraudulently, or uses a particular word in particular sense, or is or was at the specified time is conscious of a particular sensation is fact. That a man has a certain reputation is also a fact. Because if you remember the criminal law maxim, actus reus nisi means sit rea. That means an act is not an offense unless and until it is combined with the guilty mind. And the various word that shows the intention, that mens rea, like the word intention, fraudulently, honestly, or reason to believe. All these words are used throughout the Indian Penal Code that suggest that the mens rea or the mental condition. And for the mental condition also, because that is also one of the ingredients, so that also has to be proved. And for that also, when the evidence has to be adduced, so that's why this word fact also include that the psychological fact, because these fact has to make relevant under various section 5 to 55. That's why this word fact include physical as well as the opinion based fact or psychological facts. Yes, guys, any question from this definition fact? Should I move? Yes. Now I'm taking second definition, that is relevant. What do you mean by relevant? Relevant is basically, you can say, this word comes in the mind when there are two things. Okay? And how they are related. Okay? In that way, the word relevant is understood. Relevant has been defined as one fact is said to be relevant to another when one connected with other in any of the way referred to in the provisions of the act related to the relevancy of fact. Relevancy of the facts means from section 5 to 55. That means one fact is said to be called relevant to the another fact when their relationship is in such, or they are connected such as referred in the relevancy provision from section 5 to 55. Okay, and so the word relevant means that any two fact to which it is applied are so related to each other that according to the common course of event, one either taken by itself or in connection with other fact proves or render probable the past, present or future existence or non-existence of the other. Okay, so whether a person in a trial, A is the accused, and A wants to prove that he was not in the Delhi at the occurrence of the crime when the issue was of the murder of person B at Delhi. He was somewhere else. For sake of simplicity, we can say that like the Kolkata. Now, whether this fact that he was at the Kolkata, this fact he can be proved by the various things. Any person who saw that at the Calcutta airport, this is also the fact. So by these this particular fact can be proved. But the question is whether this fact is relevant, because only relevant fact has to be adduced as per the section 136. Now the question is that whether this accused was not at the time of occurrence in the city where the offense was committed in any of the way referred to in the provisions of the act related to relevancy. The answer is yes, that under section 11 it is covered, and so this person was not at that place. This particular fact that this person was at Calcutta, was not present in Delhi, is relevant to this murder inquiry. Okay, you got this, or you want to ask anything?
Okay, class.
Yes, guys, please ask anything that you want to ask from the fact and relevant, both these definitions. Or should I move further? Yes, bolo bachcho. Mr. Akash Singh,
Yes, sir.
समझ में आ रहा है फैक्ट क्या है, रिलेवेंट क्या है?
Yes, sir.
ठीक है. Now the next thing is facts in issue. Facts in issue. This is third definition. See, the this phrase itself gives some impression, some inference. Facts in issue. So those facts that are disputed, those facts whose existence is denied by one party and supported by the other party, is facts in issue. Simple example, murder का लेते हैं. A shoots B. A killed B. The trial is murder trial. So first is A shoots B. A कहेगा मैंने शूट नहीं किया, B पार्टी जो कहेगी उन्होंने कहा कि इसने शूट किया. So this particular fact, whether A shoots B or not, is denied by one party and supported by another party. This is fact in issue. Okay. A intended to cause B death, because section 299, inquiry of section 300 will go through section 299. With intention to cause death, he shoots. So with intention to cause death, that he has the intention to cause death, it is denied by accused A, again supported by B. This is also fact in issue. A had received the grave and sudden provocation. Again, it will denied by the defendant and supported by the accused. यहाँ जो grave and sudden provocation दिया, इसलिए मेरे हाथ से हो गया. So this is also fact in issue. So basically, fact in issue is that fact that is in the issue whose existence is denied by one party and supported by the another party, is fact in issue. That we can understand. Now come to the definition that is provided. ये तो हमने एक meaning निकाला. Fact in issue. The expression fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, disability, asserted or denied in any suit or proceeding necessarily follow. See, in the law, basically we apply the substantive provision. Like in the criminal trial, suppose the question is the rape. Every woman has the right that no one should, disrobe her, should drape her. And all we have this duty, not without the consent or her will, to have the sexual intercourse with the woman, to rape any woman. So that is rights and liability. Now, according to the definition, when the existence of this right and liability is asserted or denied, whether A, without the consent, has the sexual intercourse or not. So these two facts, without the consent, sexual intercourse, by those facts, their existence and non-existence is asserted or denied are known as fact in issue. So back to my earlier inference that those facts whose existence is either denied or supported, but those facts must be related to rights, because the inquiry will be related to rights and liability. Okay, so that thing, the the fact whose existence is asserted by one party and is denied by other, as a contest or dispute, may be called the soul of fact in issue. In civil cases, under this definition, there is an explanation. And to understand that explanation, first we have to understand some points. That in civil cases, facts in issue are determined by the process of framing the issue. See, the process of the civil inquiry and the criminal inquiry. Criminal inquiries को criminal judicial inquiry को हम trials बोलते हैं, civil inquiry को civil proceeding बोलते हैं, are different. सिविल केसेस में क्या होता है, फर्स्ट आप प्लेंट डालोगे, ठीक है, आप अपना पॉइंट रखोगे कि सर ये राइट्स है, उस राइट के अकॉर्डिंग ये मेरे को जो है अधिकार मिले, पर्सन बी ने दैट ब्रीच्ड, और प्लीज प्रोवाइड मी रेमेडी. In reply of that, the second party against whom you filed the case filed the written statement, WS. So plaint and written statement, and from these two, the framing of issue has to be find out under Order 14, Rule 1. See, like in our IPC, there are various sections. In the CRPC, there are various sections. In the Civil Procedure Code 1908, the first definition is code under section 2. Code includes rules. So there are 157 sections, and after that there are rules. And rules are arranged, similar rules are arranged under a particular order. So order 1, order 2, order 3. There are 51 orders. And the exhaustiveness of the CPC, you can understand that order 21 has 107 rules. Itni badi CPC. So after plaint or written statement, उन्होंने लिखा कि मेरा नाम श्यामलाल है, ये भाई साहब भी कहेगा कि ये चीज पैरा वाइज आपको रिप्लाई देना है, हाँ श्यामलाल है, डिस्प्यूट नहीं है. मेरे पास ये प्लॉट 1970 से है, ये कहेगा कि नहीं, ये प्लॉट इसने 2010 में मेरे से लिया है, वी वेहेमेंटली डिनाई. सो under Order 14, Rule 1, those facts that are present in plaint and written statement that are denied are taken as the framing of issues. Okay, so in the civil cases under Order 14, Rule 1, the court is required to frame issues on all disputed fact. From both plaint and written statement, disputed fact are to be determined. And on these, disputed fact, the fact to be asserted or denied in response to such issue. So on that particular disputed fact, either it is asserted or denied, and when it is asserted or denied, it became fact in issue. So in the simple words, you can say that fact in issue under the Indian Evidence Act became issue of fact in the language of the Civil Procedure Code. Civil Procedure Code में उसको issue of fact बोलते हैं. रिटन स्टेटमेंट मिल जाएगी, रिटन स्टेटमेंट, प्लीडिंग, रिटन स्टेटमेंट, दोनों से आप डिस्प्यूटेड फैक्ट निकालोगे. उस डिस्प्यूटेड फैक्ट जो पे एक यस कहेगा, एक डिनाई करेगा, एक उसको असर्ट करेगा. सो ये जो फ्रेमिंग ऑफ इश्यूज जिसको बोलते हैं, उनको इश्यूज ऑफ फैक्ट बोलते हैं. वही एविडेंस की भाषा में आपका फैक्ट्स इन इश्यूज होता है. ओके, नाउ कम टू द डेफिनेशन. The explanation to this definition also says similar thing. Explanation: whenever under the provisions of law for time being enforced related to civil procedure, any court record an issue of fact, the fact to be asserted or denied in the answer of such issue is fact in issue. Okay. Now, the illustration that A is accused of the murder of B on his trial, at his trial, the following fact may be in issue. A caused B's death. One will assert that yes, it was existed, he killed, he shoots, he caused the death. Another will deny it. That A intended to cause B's death. One will assert, another will deny. That A had received grave and sudden provocation. One will assert, another is denied. That A at the time of doing the act which caused B's death was by reason of unsoundness of mind, incapable of knowing its nature. One assert, another deny. So that is known as fact in issue. So from this definition, we have learned that basically for our understanding, the fact in issues are so disputed facts in a judicial inquiry, whether it is civil or the criminal, who related to the existence of the rights and liability. The another word that use the extent of any right or right. When you say that through, because the unsoundness of mind on the grave and sudden provocation, when there is a grave and sudden provocation proved from the murders, your liability comes to the culpable homicide, less liability, the less punishment. So such disputed fact whose existence either one party denies, another party assert is fact in issue, and in the language of the Civil Procedure Code, it is known as the issues of the fact. Such disputed fact that has been collected by the court by seeing both the document pleading and the written statement, and when such issue of the fact is asserted by one party and denied by another party, it became fact in issue. So in the common or simple word, you can say that in the CPC, fact in issue can be known as issues of the fact. Okay. Guys, anything that you want to ask from on this definition, facts in issue? See guys, when there is the question, the problem-based question, not in the Indian under this evidence law, even in your higher semester, higher classes also, when you are writing your answer, when it is or when you sit in the judicial exam, when it is a question of the civil law, you have to first that what the plaintiff is saying, what the other party is saying, then you have to frame the issues. And from that issues, the fact in issue you have to find out. Similarly, when the question is of the criminal case or the criminal matter, then also you have to find the fact in issue. And then through the various facts present in the question, you have to appraise that. If it is a problem-based question, if it is not that, then simply the law-based question, then you have to write the law. So should I proceed further, guys?
Yes, sir.
The next is document. I think you all have heard this word document. So can any of you tell me that what you understand by the document as a common parlance? I'm not saying that the legal definition as provided, वो हम डिस्कस करेंगे. फर्स्ट एज ए कॉमन पार्लेंस डॉक्यूमेंट का मतलब क्या समझते हो आप? यस गाइस, डॉक्यूमेंट नहीं सुना आपने? सारा डॉक्यूमेंट लेके एडमिशन आपने करवाया, जॉब्स के लिए भी डॉक्यूमेंट जरूरी होते हैं. आधार कार्ड बनवाने जाओ तो उदीची कैरी एनी रिटन स्टेटमेंट.
Sir, any paper which is important.
So
Which is
paper. Okay. Mahesh, Kunal saying any a piece of written, printed or electronic matter that. Okay. Good Kunal, good Udichi, good Akash. पढ़ने दो क्या पढ़. Any piece of written, printed, electronic matter that provide information or evidence or that serve as an official report. Very good. Yes. Any other? What do you mean by document? डॉक्यूमेंट वो मटेरियल होगा या वो कागज होगा?
Sir, anything which is important.
Okay. But in the general parlance, people say that this particular कागज, आधार कार्ड वो कागज होता है ना, this is document. Okay. So that is material on the paper. Nice, good. Now see the definition. Because what we understand in the common parlance is not applicable when the definition is clear, but sometime when there is confusion, when there is some understanding, then when you can be use your common parlance. But when the word is explained, already explained in the statute, so उसमें हम उसको कैसे use करेंगे? The document means any matter. So as many of you says that matter, any matter. Matter here does not mean that matter that you read in the physics. Matter here means any type of the that thing, the statement, the record it, that any matter, like you married to some woman, and this is also a matter. You're feeling all these things. So document means any matter expressed or described upon any substance by means of letters, figures, and marks, or by more than one of those means intended to be used or which may be used for purpose of recording that matter. So basically here matter does not mean that paper or that particular thing. It is immaterial on which it is written. Basically it refers to the matters. Any idea, matter here means any idea, and how you describe, how you express your idea. कुछ लेटर्स लिखोगे, कोई भी लैंग्वेज लाइक हिंदी में अल्फाबेट्स, इंग्लिश के हिंदी के वर्ड, इंग्लिश के अल्फाबेट, कोई भी लैंग्वेज उसके लेटर्स 1 2 3 न्यूमेरियल्स, ये लेटर्स लिखोगे. कोई फिगर उस पे बनाओगे, कुछ मार्क्स लिखोगे, हैश लगा दिया, @ लगा दिया. सो जब आप अपने किसी आइडिया या कोई भी ऐसा कोई आइडिया है, when that idea is expressed on any substance here is not material, whether you write it on the paper, whether you write it on the table, whether you write it on the fan पे लिखता है ना, भेंट करता श्यामलाल, LC1 की टेबल्स पे आपको मिल जाएगा LC1, लो फैकल्टी पे ऊपर लिखा हो बड़ा बड़ा लो फैकल्टी, अशोक के स्तंभ पे लिखा हुआ है ये शिक्षाएं. So all these is matter, whether it is written on the paper, whether it is written on the metal, whether it is written on the stone, whether it is written on the any other thing, that is immaterial, but it has to be on the substance. And substance means that you can touch it. As any Kunal is saying that a piece of written, printed or electronic matter So electronic matter would not called document as per this definition. Okay. When you will read evidence there by way of amendment, including electronic records. So that electronic records word is used, and that has been defined under the Information Technology Act 2000. There you will find. But as such per the definition, it is not written, because that matter has to express on the substance. That is electronic record, electronically served. So strictly that cannot be said. It can be maybe through the, like in the diary you have written that on the Saturday I married to this particular girl. So it is on the letters. Maybe you are writing something using the figures, that maybe, or maybe you using letters and the figures and the marks. So these became the document. Whether you intended to intended to be used, or which may be used for purpose of recording के लिए आपने लिखा. Caricature, inscription on metal plate, these are all used for recording that thing. Even like in the common when suppose there is waving done on, you write like 1, 2, 3 only by the figures, but that gives the idea, or that is used for recording. So that would also be called as document. Now the illustration, I think you have understood it, is a writing is a document. So wherever you have written, it is a document. अब यहाँ पे जो important वाली चीज है वो चली गई, because some of you have that common parlance understanding in your mind that when it is important it is document. ऐसा कुछ नहीं. Any matter that is expressed, any substance by letter, figure and marks, and that is either intended or intention भी नहीं, तो जर्नल पर्पज के लिए, रिकॉर्डिंग के लिए होता है, दैट इज मैटर. दैट मैटर इज डॉक्यूमेंट. आपकी नोटबुक डॉक्यूमेंट, आपकी डायरी डॉक्यूमेंट हो गई. आपको आइडिया भी नहीं था, आप अभी आधार कार्ड को डॉक्यूमेंट समझ रहे थे. सो द डॉक्यूमेंट and the documentary evidence here, meaning is slightly in that sense. Like first we that fact वहाँ opinion भी include कर रहा है. This particular name, where name and address is written, ये particular chip, ये पर्ची, this is also document. Okay, so a writing is a document. Whether it is important or not, that is not material. When and matter, that means an idea, is expressed or described on any substance, whether paper or any other substance, but it has to be substance, by means of letter, figure or any one or more of them, intended to be used or which used for the recording. आपने notes लिखे तो recording के लिए तो लिखे, बाद में आप देख सकते हो. This is matter. This is evidence, document, sorry. Word printed, प्रिंट करके जो आ गए वो डॉक्यूमेंट है. वो लिथोग्राफ जो पत्थरों पे लिखते हो, डॉक्यूमेंट. फोटोग्राफ, वर्ड का फोटोग्राफ, वर्ड प्रिंट करोगे, वर्ड को लिथोग्राफ करोगे, वर्ड को फोटोग्राफ करोगे, वो भी डॉक्यूमेंट हो गया. मैप, प्लान, कोई आपका मैप है, कोई प्लान है जिसमें फिगर मार्क्स यूज कर रखा है, दैट वो भी डॉक्यूमेंट हो गया. एन इंस्क्रिप्शन ऑन ए मेटल प्लेट, इसी मेटल प्लेट पे आपने कुछ लिखा, दैट स्टोन पे आपने कुछ लिखा, दैट इज आल्सो डॉक्यूमेंट. आप देखते हो जो व्हेन ए पर्सन इज buried ऑन हिज ग्रेव, समथिंग इज रिटन, दैट इज आल्सो डॉक्यूमेंट. उसको भी लाओ उखाड़ के, लो फैकल्टी पे बड़ा बड़ा बोर्ड में लो फैकल्टी लिखा हुआ है, that is also document. एक कैरिकेचर बनाते हैं ना, कैरिकेचर, दैट इज आल्सो डॉक्यूमेंट. सो दैट इज सर समथिंग रिटन ऑन वंस हैंड, डॉक्यूमेंट. डॉक्यूमेंट है भैया, आपने देखा नहीं? Yes, Viswajit, I am coming. That one interesting, that once I was giving the duty in the examination, and one girl was writing on, has something written on her hand. तो वो मटेरियल था जो उस पे लिखा हुआ था, उसने पेपर पे भी लिखा था. अब इसमें था कि ये भी तो डॉक्यूमेंट हुआ ना, इसको कैसे वहां पे जाके प्रूव करोगे आपको कि इसने जो है नकल की है, अनफेयर मीन्स यूज किया है यूएफएम जब बनाते हैं, हाउ यू विल प्रूव इट? सो वन इज माय ओरल evidence. As a witness I give that I saw there was written. Another is that this thing is this particular, so that may be उससे मिलान भी होगा कि अब हाँ ये क्या, ये लिखा हुआ है. सो फिर एक टीचर ने तो उसका पूरा ऐसे रखवा के ना और फोटो स्टेट ही करवा दिया था, पूरा हाथ का उस पर लिखा आ गया. कई लोग फोटो ले लेते हैं, ठीक है, अक्यूज पे टैटू वगैरह या और कुछ होता है उसको भी वो फोटो ले लेते हैं. यस, विश्वजीत आस्क दैट is a satellite image document. See, satellite image or whatever map, but when it is printed on something, it became document. Otherwise, when it remained in the in the electronic form, it is electronic record. But when it comes to on any printing, on describe on any substance, it became document. So see, simple विश्वजीत, लाइक आइडिया मेरे मन में है, अभी डॉक्यूमेंट नहीं, कहीं मैंने लिख दिया डॉक्यूमेंट हो गया. सिमिलरली इमेज जब तक है, जब तक वो प्रिंट हो गई तो डॉक्यूमेंट. ओके, सो सर कैन वी से दैट डॉक्यूमेंट इज प्रूफ ऑफ एग्जिस्टेंस? नो, अभी प्रूफ में मत जाओ. अभी don't jump to that on the last stage. डॉक्यूमेंट इज नॉट दैट डॉक्यूमेंट है तो वो प्रूफ है. डॉक्यूमेंट है, फैक्ट है, वो कितना इंपॉर्टेंस होगा, कितना एविडेंशियरी वैल्यू होगा, कितना चेन ऑफ पूरा कंसीक्वेंस को कंप्लीट करेगा कि नहीं, प्रूफ किसको कहते हैं, वो हम पढ़ रहे हैं धीरे. अभी डोंट जंप ऑन द लास्ट स्टेज. ओके, सो डॉक्यूमेंट डज नॉट मीन प्रूफ. सो गाइस, कैन आई मूव फॉर द evidence? Evidence means and includes all the statement. Very interesting definition. All the statements which the court permits or required to be made before it by witnesses in relation to matter of fact under inquiry. So evidence means and include, and there are two category, like the fact की two category है ना, physical fact and psychological fact. Similarly, evidence means and include, and then there are two category. One is oral evidence, another is documentary evidence. Part A, one is says about the oral evidence. So oral evidence क्या है? All statement. अब statement कौन देगा? कोई आदमी देगा statement, any person. So all statement which court permits or required to be made, which court permits. If court will not permit, it is not oral evidence. A, confess before the police officer, पुलिस ने मार के confess करवाया होगा. Now this person B is giving the statement that कैसे A ने confess किया. Court will not permit it, so it is not oral evidence. All statement that court permits or required to be made, that are not required to be made, like section 56, 57, 58, certain facts that need not to be proved. Proved मतलब उसको oral या documentary कैसे prove है, उनका कोई oral evidence वहां statement दे रहा है, court कहेगा इसकी जरूरत ही नहीं, that is also not oral evidence. So all statement, that mean oral evidence statement होता है भैया. Oral evidence मतलब orally जो बोलते हैं, that mean all statement which court permits or required to be made before the court in relation by witness in relation to matter of the fact under inquiry. With respect to any inquiry, civil or criminal, when the court either allow or that is required to be made in the by the witness, those statement are known as oral evidence. Now from here two things we can understand. Oral evidence तो हमने ले लिया कि oral evidence are those evidence. Oral evidence are basically the statements made by the witnesses in the before the court of law in any inquiry that court either permits or required to be made. ठीक है? What is witness? Any person who depose oral evidence before the court of law. So if कई बार होते हैं बड़े तेज लोग होते हैं, सिंपल सी चीज पूछते हैं, आप कंफ्यूज हो जाओगे. लॉ क्या होता है? आपने कहा लॉ कर रहे हैं, लॉ क्या होता है? विटनेस क्या होता है? एनी पर्सन हु डिपोज ओरल एविडेंस इज विटनेस. सो आप एक डॉक्यूमेंट लेके गए कोर्ट में, आप विटनेस नहीं हो गए. आप विटनेस तब बनोगे जब आप कोर्ट के सामने ओरल एविडेंस डिपोज करोगे. ओके, so any person who depose oral evidence before the court of law is known as witness. Now come to the second definition, the second part. All documents including electronic records. This word including electronic records has been inserted by way of amendment in 2000. What are they now? Before that there was only documentary evidence. So all documents as defined earlier and include electronic records. Because electronic records are present in the chip, you cannot say that is the matter described on a particular substance. So that special category electronic records we called it. Produced for inspection of the court. So all document and electronic records, you can say, all document that include electronic record also produced before the court for inspection is, such document is called documentary evidence. So a contract, when you produce before the court and the contract is on the question, the registry of a property, that is also, a document, and when you produce it for the inspection, court will see it, it is documentary evidence. Call record, that is as electronic record, then printed on the paper, it is became document. और वीडियो आपने जो रिकॉर्ड की है उसको आपने पेपर पे नहीं किया, डायरेक्ट वीडियो ही आपने कोर्ट में चला के की, दैट इज फॉर इंस्पेक्शन. इलेक्ट्रॉनिक, अदर इलेक्ट्रॉनिक रिकॉर्ड that you produce for inspection, that is also documentary evidence. So the evidence, definition of evidence include both oral evidence as well as documentary evidence, and also includes the electronic records. The word evidence signifies in its original sense the state of being evident, plain, apparent. So when orally you say, that became plain, apparent before the court, किसी को suggest करता हो, influence करता हो, और जो आपने पेपर, जो आपने documents किया है, that evident of something, it is known as evidence, as the, you can say, literal meaning. Evidence, if you say and understand, can be categorized in three categories. Here is 2 category. But as a journal, evidence can be of 3 category. One is the oral, to the statement you say. Another is the documentary. And third may be the material. Stolen property, आपने stolen वो property produce की कि सर ये सोने का क्या कहते हैं उसको घड़ी थी जो चोरी हुई. अभी सोने की घड़ी जो है ये आपने दिखाई कोर्ट में इंस्पेक्शन के लिए, बट ये कोई मटेरियल तो है नहीं, कोई आइडिया तो है नहीं दैट इज एक्सप्रेस, दैट मीन ना तो डॉक्यूमेंट है ना इलेक्ट्रॉनिक रिकॉर्ड है. सो एज पर दिस डेफिनेशन इट इज नॉट एविडेंस. समझ रहे हो? सो एनी मटेरियल और रियल थिंग, सर ये पिस्टल है जिससे शूट हुआ, सर ये चाकू है जो स्टैब किया. अभी चाकू तो कोई डॉक्यूमेंट नहीं है. So that material is not evidence as per our definition. So 3 evidence is generally can be categorized in 3 category: oral or personal, documentary, and third one is material or real. But the Indian Evidence Act only recognize first 2 category. Real or material evidence is supplied by the material object for inspection of the court. Is that weapon of offense, stolen property are not evidence as per the definition. A police officer has to send to the magistrate, yes, fingerprint I will come to, any weapon or other article when upon the investigation, evidence to be found to be sufficient against the accused, section 170, clause 2 of CRPC. Under section 60 of the Indian Evidence Act, court may require the production of material thing for inspection. Strictly speaking, such material is not evidence under the Indian Evidence Act. Yes, someone has asked very interestingly, this is really, because evidence law is very interesting and it is core of every judicial inquiry, whether it is civil or criminal. कितना भी आपको substantive law आता हो, but if you don't know the procedural law, you cannot win, you cannot decide the case. You will see this thing, that you know the substantive law, but when you appear in the judicial exam where subjective question is asked, you will face difficulty that how to decide it. Sir, fingerprints also come under the document. See the fingerprint, whether it is letter, whether it is mark, or whether it is figures. Can any of you tell me that fingerprints, marks? If it is marks, yes, it is a document. Okay. Kunal? Udichi is saying that fingerprints are marks. Yes. So the definition of evidence, or you can say that the definition of evidence as provided by Indian Evidence Act is incomplete and narrow. Many teachers will used to say, and many person will used to say that so nicely drafted Indian Penal Code, so nicely drafted, the Indian Evidence Act, but that is not true. Woman always has flaw. Perfect is God. So this definition of evidence is incomplete and narrow. Okay. Now, to more understand the evidence, we have to see this definition of understand with the definition of proved. The combined effect of 2 definition is not only the medium of proof, but in addition to there are many numbers of facts which the court has to take into the consideration while framing its judgment. डेमिनोर, किसी आदमी का डेमिनोर कैसा है? जस्ट गिव मी 1 सेकेंड। कौशिक साहब नमस्कार। So the medium of proof is not important, but the other number of consideration that judge take in its consideration while deciding the case, like the demeanor of the accused, demeanor of the person, that may be one such, the material that is produced, firearm, माल मुकदमा जिसे बोलते हैं, या केस प्रॉपर्टी, so that is also taken into consideration. Maybe that is not covered under the definition of evidence, but yes, they play certain roles to deciding the case. Just take the consideration of these things also. Okay. Now, come to the certain category that I want to ask. Whether fact judicially noticeable under section 56 to 58 are evidence as per our definition or not? Yes, guys. Fact judicially noticeable under section 56, 57, 58 of Indian Evidence Act, whether those fact, the oral or the documentary proof of those fact will be evidence or not? Yes? No? Because fact judicially noticeable means there are certain facts which need not to be proved. When you read section 56, there is one chapter on that also, fact that need not to be proved, that we have to discuss. That on the Sunday there was holiday, whether it need not, it has to be proved or not. Section 56, fact judicially noticeable need not to be proved. No fact of which the court will take the judicial notice need to be proved, and the court shall take the judicial notice under section 57 all law in force in the territory. Whether there is a question that IPC is applicable in Delhi or not, इसको प्रूव नहीं करना है. All public act passed thereby by the parliament, etc. Articles of war, course of proceeding, accession of sign or manual, seal of English court, territories under the dominion, name and member of the officer of the court, rule of road, rule of law, rule of road कि हमें left में चलना है. So there are certain fact that court take the notice of it. So there is no need to prove those facts. If you see the definition of evidence, the first part, that all statement which court permit or required to be made, but these are not required to be made. That we have to walk on the left of the road. This statement is need not be required to be made because these are the fact judicially noticeable, and so this is not evidence. So what is not evidence? One is fact judicially noticeable, material objects, the case property, all the material object under section 60 of the Act, Indian Evidence Act, are not evidence. Demeanor, witness का demeanor, not the accused का demeanor. Witness का demeanor etc. वो भी ना तो oral evidence है और ना ही documentary है. So demeanor भी under section 36 of the CRPC, 361 of CRPC and order 18 rule 12, that is also not evidence. Confession or statement of one accused under section 342 of CRPC, or you can say the confession as made under section 25, if that has to be proved by oral or documentary evidence, so that would also not be evidence. In state of Maharashtra versus Dr. Prafull B. Desai, the Supreme Court held that under section 3, electronic record can also be admitted as evidence. Nothing, new in it, but because this is the old judgment of 2003. So there the electronic record, the question was whether electronic record can be admitted or not. So that time this was decided by the Supreme Court. Now it is well in our Evidence Act by the amendment. Another question is first information report. FIR आप लिखवाते हो, in the FIR there is the some statement, the factual statement. Sir, I was going on the road, then I saw that person A was running after person B, then A stabbed to B. So all this factual, statement that you find in the FIR, and that has not been deposed by the informant before the court of law as a witness, whether that FIR would be evidence or not. Yes, guys. So in Ramdas versus State of Maharashtra 2007, it has held that the factual statement which find place in the FIR but not deposed by the informant or other witness can not be treated as evidence in the case. As a journal in the criminal law, that FIR does not have any evidentiary value. FIR में जिसने कहा है या तो वो कोर्ट के सामने आके डिपोज करे, ओरल एविडेंस दे, ओके, उसका उससे ज्यादा एविडेंशियरी वैल्यू नहीं है. एज ए डॉक्यूमेंट दैट इज एविडेंस, but as such it does not have more evidentiary value. Now from here we can discuss certain types of evidence. First is oral evidence and documentary evidence as categorized under this definition evidence. Primary evidence and secondary evidence. Primary evidence, that if it is the evidence of something that can be seen, the person who saw it, with the evidence of something that can be here, so the person who heard it. And the secondary evidence is the hearsay evidence in case of oral. In case of document, the original contract is the primary evidence. The photocopy of it is the secondary evidence. So primary evidence, secondary evidence. And best evidence or original evidence is known as primary evidence. The best evidence rule exclude the secondary evidence. Okay. English writer also divide the evidence into two categories: indirect evidence, positive evidence, and indirect or circumstantial evidence. Now the circumstantial evidence, like in case of the psychological fact we have discussed, that whether A has the intention to kill B or not, it can be proved by direct or circumstantial or indirect evidence. It's direct by making the confession, because he has the conscious of his mental condition. Circumstantial evidence by his conduct, where he fired, on which part he has fired, all these things. So in the proof of the circumstantial evidence, the motive and opportunity are regarded as two crucial tests of the circumstantial evidence. where there is no direct evidence, the court cannot say, or the whole judicial process cannot say that there is no direct evidence, so we will not convict it. The proof is also, has to be decided by various facts. A was holding suppose there is no eyewitness whether A killed B or not. The offense was committed by a firearm, pistol's offense. A was holding that particular revolver when the police caught him. The ballistic report suggests that the bullet was fired from the gun that was recovered from this this accused. And the third, that the death was caused by that. So this is the circumstantial evidence that A fired to the B and by which the death was caused. A causes the death. Whether he was intended or not, that is another fact. But the first fact that A caused the death of B is proved, these circumstantial evidence. There was no eyewitness who saw that A fired. And so for the circumstantial evidence proof, the proof are regarded as two of the crucial tests of the circumstantial evidence. Circumstantial evidence must be both exclusive and conclusive. Exclusive means they exclude the possibility of innocence. And the conclusive means they conclusively prove the thing. Four things are essential to prove the guilt by the circumstantial evidence. That the circumstances from which guilt is established must be fully proved. That all the fact must be consistent with the hypothesis of the guilt. Consistency should be there. Circumstances must be conclusive of nature and tendency. And the fourth one is that the circumstances should actually exclude every hypothesis except one proposed to be proved. There must not be any possibility of any hypothesis of innocence. In Veer Singh Kolhari versus State Bank of India AIR 2009, it was held that affidavit is not evidence within the meaning of section 3, because why the affidavit is not the evidence? Because affidavit is sworn statement, and that statement has not been made before the court. Okay, so in that sense it is not the evidence. Evidence as such, it is written in a document, but basically it is statement. When in the trials you will see, or in the judicial inquiry, you will see when the chief engineer want to depose, he will depose through the affidavit, etc. So the affidavit in that sense is not evidence as per our definition, as decided in the Veer Singh Kolhari versus State Bank of India. But don't worry. As I said, that for making the decision, judge is not bound only to take into the consideration the evidences as per the definition. Other things also he has to take into the consideration. Now, the another issue is that when there is the oral evidence by the eyewitness, so as a man there would be the discrepancy. पहली बार वो क्रॉस में कुछ कहेगा, थोड़ा बहुत वेरिएशन आएगा, एसी ऑन कर. Then maybe the original statement में उसने कुछ कहा, फिर depose, when he was deposing before the court, there is a slight discrepancy, and these discrepancy you will see, because the proof, judicial proof, is not like mathematical where the complete or the absolute proof. At one, you have to satisfy yourself, and in the definition of proof you will understand that. So the Discrepancy that is a trivial and not amount to any contradiction does not render the prosecution evidence the doubtful. Okay. Then there are certain type of the witnesses according to their situation. One is interested witness. Interested witness means उसको गवाही देने से कुछ फायदा होगा. A killed, A raped B. There is an allegation that A raped B, and the brother of B is giving the, oral evidence as a testimony. So B is, in that sense, the interested witness. But that does not mean that interested witness is always, seen as the doubtful. Naturally, जहां offense होगा वहां पे घर के लोग ही होंगे. Okay. But sometime, as such, there is no rule of law that interested witness testimony is seen as, with the doubt. That is not as a rule of evidence and as a rule of caution or as a rule of providence. Chance witness. The murder was committed at broad daylight on a particular street, and as any of you saw it. But how you were present there, that was by chance. So that is chance witness. Sometimes the chance witness, in that case, the second party, the cross examination will say that why you were present there. ऐसा तो नहीं कि झूठ मूठ में इसको ट्रांसपेरेंट किया है. पुलिस विटनेस, तो पुलिस वहां गई तो हमने देखा कि इसके हाथ में बंदूक थी. So that is also very important evidence. When you giving the oral testimony that the accused was holding the gun, और उससे धुआं भी निकल रहा था हल्का हल्का. So in the police duty in the jail, the police officer बड़ा चढ़ा कर बोलते हैं. So the police witness, how you will see as a judge, you have to take that feel of that eyewitness. What is the subsequent conduct of the eyewitness by which the truthfulness or the credit of the witness can be breached. So all these type of the things. Now come to the next is proved. The next definition is proved. Here there are three things: proved, disproved, and not proved. Proved means when you prove something. Not proved does not mean that it is false. Okay? Proved, a fact is said to proved when, after considering the matter before it, court either believe it to exist or consider its existence so probable that a prudent man ought, under the circumstances of particular case, to act upon the supposition that it exists. So here the proof under the Evidence Act and in the judicial inquiry is not as like in the mathematical, the absolute proof. Here the proof means either that through the different fact it is sufficiently proved, like whether the bullet was fired from this gun A and the ballistic report suggests that in most probability yes, so it is proof. But that the death was caused by falling from the house, and the doctor says that yes, the death can be caused by if a person fall from this height on the hard surface, and there was hard surface. So yes, it is proved. So fact here, it's not saying that the case is proved. The fact is said to be proved. So suppose in a murder inquiry, whether A causes the death of B, whether A intended to cause of the B, these are the various facts, the fact in issue that one asserted and denied. So one particular fact, whether it is proved in the fact in issue that whether A caused death, A fired or not, that from that fire only, by the medical report, the death is caused. Because koja kajona also has to be established. Death बंदूक से हुई कि पहले मरा पड़ा था. Okay. So whether the bullet was fired by this person or not, this particular pistol or not, that is one fact that has to be proved. Whether a fact is said to be proved after considering the matter before it, the court either believe, yes, exist, yeah, consider that its existence is so probable. Maybe there is slight doubt, but probability is so high that a reasonable, a prudent person ought under that particular circumstances, हाँ ये हो सकता है. So that is possible. So here that absolute proof is not required when the existence of that particular fact is believed to be proved by the court, or in that circumstances there is most probability of proving or existing that fact, then it's said to be proved, the proof. Okay, so so whether there was a civil dispute, and the question was that A inherited, or through the will A inherited that property from his father or not, and that will, that well produced by his lawyer, and no other second will is proved in that situation. If court prove that yes, this is original will, so that means this fact is proved. Or in that will, that particular thing is written that after my death, my son will inherit this property. This court believes, and the will is original, so the no second will is there, and etc. All others in that circumstances, a prudent mean that it is most probable, so that is also known as proved. When a fact is not proved, that does not mean it is false. When in a murder trial, the fact that whether A causes death of B, and by the proving by oral and documentary evidence it has not been proved, it is not proved, that does not mean that A did not causes death. That just means that it has not been proved. So proved, not proved, and then disproved. Disproved is the actually opposite to the proved, when there the fact existence is completely denied. But not proved is the situation where the person or the party is not able to fully prove it or fully disproved it. So in that situation, it is known as not proved. Disproved, a fact is said to be disproved when, after considering the matter before it, the court either believe that it does not exist, or consider its non-existence is so probable that a prudent man ought, under the circumstances of particular case, to act upon the supposition that it does not exist. So it is exactly opposite to the word definition proved, that a fact is said to be disproved when, after considering the matter before it, court either believe it does not exist, or its non-existence is so probable that an prudent man ought, under the circumstances of the particular case. So whether A causes death or B, that fact, if the defense is able to prove that A did not cause the death of B, or in such a circumstances that A at that time was in the America, how it can cause. So in that particular circumstances, it is probable that the non-existence of causing death by the A, and so this particular fact is said to be disproved. Not proved, a fact that is not to be proved when it is neither proved nor disproved. Now there is the burden of, or the benefit of doubt. See, the as such, the proof and disproof, the same thing is applicable for the civil and the criminal cases. Whether court it believes it, or its existence is so probable in the circumstances that an original man ought either to prove or disprove. But as such, if you see that the burden of proof in the civil and criminal cases are different. In the criminal cases, it is beyond reasonable doubt, and in the civil cases, it is preponderance of probability. Okay. As such, we have earlier discussed also that the Evidence Act apply both to civil and criminal cases equally. But some principles like the estoppels applicable to civil cases, confession applicable to criminal cases also. The rule has stated that nowhere enacted, but it is not the rule of law, but the rule of prudence founded on the public policy as the consequence of wrong conviction are much more serious damage caused to the society than the non-convicting of the person. And so punishing one innocent cannot be excused, and or you can say in other words that maybe 10% go unpunished, but one innocent cannot be punished. And this maxim that as such is not the rule of law, but it is rule of prudence. This applies the greater burden in the criminal trial, that is beyond reasonable doubt. There should not be any doubt, any theory that shows the innocence of the victim, accused. If accused is treated as innocent till it is condemned by the court. And police में क्या होता है? Police call accused as, the person as accused till the innocence is established in the court. Okay. So in the criminal cases, the benefit of doubt is important phrase that you will see, and the benefit of doubt is given. The fundamental principle of criminal law is founded in the Roman legal system. It has no application to the civil, and benefit of doubt cannot be given to the defendant. The prosecution must prove the corpus delicti, the fact that offense charged has been committed by someone. Then it must prove that accused has committed the crime. So both that the offense, that this particular offense has been committed and it has been committed by the accused. And when there is any possibility of creating the doubt that this person has not, committed this particular thing, then the benefit of doubt has to be given because of that rule of prudence in the criminal trial, that 10% may go unpunished, but one innocent must not be punished. Or you can say the burden of the beyond the reasonable doubt. So the doubt create kar dete ho, so that may be, used in the criminal trial. No man can be convicted where the theory of his guilt is no more likely than the theory of innocence. Theory of his guilt must be greater than the theory of his innocence. Okay. So suspicion, however so grave, cannot take place of the positive proof, because suspicion is the sea and that has no shore. So suspicion cannot be called and cannot be used as evidence. Evidentiary value of last seen together, the evidence of being last seen relied upon any or may form the basis of the conviction when, however, would depend upon the fact and circumstances of each case. In some cases, the court also look for the corroborative evidences. Now, as such fact, the evidence are not counted if you see section 31 of the Indian Evidence Act that talk about, but evidence has to be weight. A oral statement, how much weight it has, a document, how much weight it has, all these things we will discuss when we will discuss the proof. So as a judge, now, you will have to find out that how much weightage you are giving. But now we are discussing only that, which particular things are admissible, what is fact in issue, etc. Section 31 says that admission are not conclusive proof, but they operate as estoppel under the provision. And section, sorry. Basically, it is about admission. Okay. But sorry, I uh, give them. There is another provision that says that evidence, as such, the how many number of evidence is required, that is not counted, but the quality is dependent. So this is all about these words, these 8 words: fact, fact in issue, relevant, document, evidence, proved, disproved and not proved. एंड उसमें आप एविडेंस में ओरल एविडेंस, डॉक्यूमेंट्री एविडेंस भी कर लो, तो उस हिसाब से 10 हो जाएंगे. So these 8 terms we have defined. The fourth part is about the relationship of the Indian evidence with civil and criminal law. So I think much discussion we had, and so more specific discussion is not required. So from next class we will start the next chapter, that is of relevancy of the facts, I think. So that chapter we will start. Now if you have any question with respect to the first chapter, you can ask with respect to the specific discussion we had related to these definition. You can ask me in 1-2 minutes, and then I will leave the meeting. Yes guys, any question?